let's go over factual impossibility as a defense to attempt. Again, factual impossibility as a defense to attempt. Factual impossibility, the definition is, the defendant attempts a crime but could not complete the target offense due to facts unknown to him. It's not a defense, and I want you to know that. Again, factual impossibility is no defense to attempt. The definition again is, defendant attempts a crime but could not complete the target offense due to facts unknown to him. Let me give you some examples, some very, very simple examples. Defendant is charged with attempted murder. What he does is he shoots to kill, he shoots in a window at the victim's bed, but the victim was not in the bed. So facts known to him, he thought the victim was sleeping, but unknown to him, the defendant wasn't there, but he still put his hand in, still shot, and tried to kill somebody in the bed. Just because the victim was not in the bed doesn't mean we're not going to be able to hold the defendant guilty for attempted murder. He still intended to kill somebody, and just because of facts unknown to him, he was unable to complete his target offense, which was murder. So he would be charged with attempted murder. Another one is where the defendant shoots to intend to kill, but the gun is unloaded. If he thought the gun was loaded and he shot with the intent to kill, he is going to be charged with attempted murder. Another one, which is a larceny. Let's use a larceny as an example. It's where the defendant puts his hands in someone's pocket to steal his wallet, and unknown to him, he doesn't have a wallet in his pocket. He comes out empty-handed, has no wallet in his hand because there is no wallet in the pocket. He still attempted it. Just because the facts known to him, meaning there was no wallet inside the pocket, doesn't mean we're not going to still charge him with the attempt to commit the actual crime. Again, so factual impossibility is when the defendant attempts to commit a crime but could not complete the crime due to facts unknown to him. So that's it for the area of attempt. Now let's move forward and go over conspiracy. That is the third area under inchoate crimes. So conspiracy, the definition of conspiracy is an agreement between two or more guilty parties to commit a criminal act. Conspiracy does not merge with the actual crime. It is a separate offense. So remember, we talked about solicitation. Once he solicited someone and that person then commits the crime, solicitation merges with the target offense. Merger is huge on the bar exam. You got to know this distinction. However, when it comes to conspiracy, conspiracy is a completely separate offense. And once the agreement has been made between two guilty parties to commit a crime with the intent that that crime be committed, then they are guilty of both the conspiracy and the completed target offense once they actually commit the crime. So you need to make note of that. Conspiracy at common law had two elements. I'm going to go over those with you. Number one, they must have a specific intent that the targeted offense be committed. That's number one. And number two, they must have an agreement between two or more guilty parties. All right? So I want you to note that at common law, if one was found not guilty of conspiracy, then the other one could not be found guilty of conspiracy because two or more had to agree to complete a crime. Okay? If one is found not guilty, then both are found not guilty of the conspiracy. You got to know that. And then conspiracy under the Model Penal Code, which is also the majority and what you would follow on the MBE. I want to go over real quick with you on the MBE. Bar review companies, I hear them all the time saying, follow the common law, follow the common law. That is right and wrong. You have common law and you have Model Penal Code law. Some states follow the common law, some states follow the Model Penal Code. What the MBE is looking for is they're looking for you to tell them which law the majority follows. On the bar exam, common law for criminal law is usually the right answer. And it's usually the right answer because most states still follow common law on the majority of the legal issues. There's one exception, and we're going to talk about it when we get to burglary. Burglary is always follow the common law unless they tell you otherwise. Again, when we get to burglary, always follow the common law unless they tell you otherwise. And you have to be watching out for the call to question in criminal law questions, because sometimes they're going to say to you, answer according to the model penal code, or they're going to give you a statute and you have to follow the statute. So you have to be very careful about and specific about what law they're asking you for. If they're silent on it, you're going to follow the majority, whatever the majority is. And oftentimes the majority is still following the common law. Okay? The one exception to that rule, once again, is in the area of burglary. You're always going to follow the common law for burglary, and I'll get to that when I go over burglary. So let's get back to conspiracy under the model penal code and the majority, which is the MBE, is what you want to follow. There are 3 elements that you need for a conspiracy. Number 1 is the intent. Number 2 is an agreement between 2 or more guilty parties. And number 3 is an overt act or a substantial step. And we talked about the substantial step earlier. Again, let's go over those 3 elements that you need for a conspiracy under the model penal code, which is also the majority, and what you want to follow on an MBE. When you have an essay question, you've got to discuss both. You've got to let the reader know that you know the difference between modern law and common law. Point out, you'll say in some jurisdictions, da-da-da-da, and other jurisdictions, da-da-da. Whatever it is, you have to explain the little key nuances between the majority, the common law, and the modern law, okay? So the 3 elements for conspiracy are the intent that the crime be committed, the agreement between 2 or more guilty parties, and an overt act, any preparation, or substantial step in furtherance of the crime. One co-conspirator under the model penal code can be found guilty without the other. Only one party need make an overt act, okay? Once again, one co-conspirator can be found guilty without the other, and only one party needs to make an overt act. So I want to give you an example of an overt act, and that's casing the bank, buying a gun, making a plan. That is an overt act, okay? It's less than a substantial step. It's just an overt act. That is conspiracy. I want to go over with you withdrawal as a defense to conspiracy. And I want you to know that at common law, which is the majority and what you want to follow on the MBE, there was no withdrawal to a conspiracy charge once the agreement is made, period. The moment the agreement is made, the crime of conspiracy is complete. There is no effective withdrawal. Again, that is the common law rule, it is the majority rule, and it was what you will follow on the MBE. However, I want you to know that once a defendant has made a withdrawal to the actual crime, it will be a defense to crimes that are committed in furtherance of the conspiracy. He's still going to be found guilty of the conspiracy. So let's give you an example. A and B agree to rob a bank. B goes and decides he's not going to participate in robbing the bank, and he informs all the parties that he's not going to participate in the bank robbery. He tells the police, so he goes, does the attempted to thwart it by informing the police. Is he going, and let's say A then goes and still robs the bank. You know, the police don't believe him, blah, blah, blah. And he goes and commits the crime. And during the commission of that crime, someone is killed. Are we going to hold B liable for the acts of A? No, not if he has gone through the steps for an effective withdrawal, okay? So be very consciously aware of that on the MBE question, because they're going to give you facts. We're going to tell you that they agreed, and then one guy backs out, and then he goes and tells the police. He does everything he has to do, and then the crime still is committed, and they're going to ask you what B is guilty of. B is only going to be guilty of the conspiracy if he made an effective withdrawal.